Ajay Singh, the potential new owner of Spicejet, has been very ambivalent about doing an open offer to Spicejet's shareholders after assuming control of the airline from the Marans. That's because there is probably a window of exemption available that Mr. Singh may be hopeful of using. Sandip Bhagat, partner at S&R Associates, joins us now to talk us through what that window of exemption could potentially be. Sandeep, this is a general exemption available under the Takeover Code, which is available to certain schemes. Spice has called its scheme a scheme of reconstruction. Would it qualify as a scheme that could avail of that kind of general exemption?
So the way I've understood the Takeover Code exemption would be that it relates to a scheme of arrangement involving the target company. But to me, that would, at least the way I've read it, is a scheme which is a scheme under the Companies Act, which would therefore be going, you need to go to the court, and before you go to the court, SEBI today says you need to come and get a SEBI, the scheme needs to be approved by SEBI and, common process. That's the way I've understood that exemption to be. There is an exemption, yes, for a Takeover Code.
And that exemption would apply to a scheme of reconstruction?
It would apply to a scheme of reconstruction, correct.
So this is what Ajay Singh can avail of if he doesn't want to have to spend money on, an open offer, so to speak. He can avail of doing this transaction through a scheme of reconstruction that could avail of such a general exemption under the Takeover Code.
Yeah, correct. He could technically, but again, the scheme, the process today for a scheme is that before you file a scheme with the court, you have to actually go to the stock exchanges. They give they review it and give comments. SEBI reviews it and gives comments. And SEBI does even at that point have the ability to look at a scheme and say, wait a minute, I don't believe the scheme should go through because you are going around the open offer obligation. So there is that initial block itself which somebody has to go through to get a scheme approved.
The management hasn't been forthcoming with too much detail on how or what exemption they're looking at, if they're looking at one. But it doesn't seem like they're looking at an open offer, because there's every question to them about an open offer is sidestepped. If using or availing of this general exemption through the scheme method is going to be so difficult, is there anything else available to them?
So two things. One is in the exemption itself under the Takeover Code, there's a reference to a competent authority. So I'm not too clear if the plan of action here is that they will not go even to the court, but they will say that, look, the exemption states that I can get approval from a competent authority. The authority here is the Ministry of Civil Aviation, and therefore I don't need to do anything more once I get that approval.
So the scheme could be approved by the Ministry of Civil Aviation, and once having received that approval, it could be eligible for an exemption.
Well, I don't know if that's what they're planning. I'm not too clear.
But if that was what they were planning, hypothetically, would you think that would pass muster?
So again, I'm not too sure the Civil Aviation Ministry has the ability to look into. It is looking at what is happening with the aviation industry. This is a question of whether minority public shareholders, need to get the benefit of an open offer or not. So I'm not too clear how an order of the Ministry of Civil Aviation
is an order from a competent authority.
Would be an order from a competent authority to give you an exemption. There is a overall exemption which SEBI has, which the regulator can exempt any transaction from an open offer, but then the regulator has to then internally think about, why am I exempting this offer? Yeah, I understand this is a distressed airline, but there will be other companies who will then come to me and ask me for the same exemption. They'll have to treat everybody at par. So, there is the other exemption available.
Even under general exemptions, if they were declared a SIC company or had filed under SICA, they could avail of an exemption. But I don't know if aviation comes under industrial undertaking and therefore can file under SICA and therefore avail of this exemption at all.
So I think there's also, overall, if you look at it, there are both time and cost issues relating to it. If you're going to go through a scheme through a court process, you're looking at a 3-6 month process.
Right.
If you're going through an open offer, if they're not getting even that is another 3-month process. Meanwhile, you are looking at a company which needs money today. It needs it in the next month. How are you bridging the two?
Okay.
Is this one way of saying that, look, we aren't going to do an open offer because we believe we are covered. We're also not going to go to court because we believe that there's a reference to competent authority, and therefore we believe we can wrap this up pretty quickly and conclude the transaction and go ahead and
just on the basis of a nod from the Civil Aviation Ministry.
Yeah, correct.
Now, had they gone through court, sorry,
no, but SEBI can come in and ask them later?
SEBI can question if they do not do an open offer, correct. And I would assume they've already had some level of discussions with all the regulators to get a sense of where they are before they take the decision not to do an open offer.
Okay, if they went through the court route, shareholders would get a chance to vote on the scheme?
They
shareholders and creditors.
Yeah,
if they go through the competent authority, i.e. Ministry of Civil Aviation route, shareholders have no say in this transaction.
Correct.
Right?
Correct.
I'm not suggesting that shareholders would not want the Marans out and Ajay Singh in because they need this airline to get back on its feet. But I'm just pointing out to shareholders the options available right now. What do you think the way they seem to be structuring this? Okay, so this is the billion-dollar question. This is what you charge many billion billable hours for. Right?
I think right now, I mean, they've said they don't want to, I mean, at least the public statement seems to be we are not going to do an open offer.
Yeah.
You know, it's subject to what the lawyers are advising them. If they are going to take advantage of the exemption in the takeover code, the conservative reading would be it's a scheme of arrangement. You have to go through the court process. Before that, you actually have to go to SEBI. And the current SEBI regulations say that any scheme, you need majority of the minority also to approve a scheme. So the public shareholders have a big say in that. It is a timing issue also. You're not looking at getting this transaction done in the next month.
Right.
You are looking at a timing later than that. So if the business issue is we need to close this soon and today, then
you're almost making a case for how they're going about this and therefore not doing an open offer. You're almost making a case for that.
I'm analyzing it. I don't necessarily agree with the fact that the particular exemption under the takeover code means that one particular regulator can say this scheme, it's a scheme, it's fine with me, and therefore I don't need to really necessarily follow the open offer exemptions or not. I mean,
okay. So if SEBI were to be faced by an approval from the Ministry of Civil Aviation on the basis of which Ajay Singh and the Marans say, look, please give us an exemption, from an open offer, what do you think SEBI's position could be? I'm asking you to base this on past precedent.
Past precedent, I mean, again, so they will then go to SEBI and say, look, you have general powers as exemption. Don't look at the specific exemption relating to schemes, etc. You have generally powers to exempt us. We are an airline, we are in distress, it's for the public good.
So how will SEBI react?
It's a difficult question to answer, because I think usually the regulator will say, I can't give one company an exemption without then having to look and say that tomorrow any other company in the same position should not be able to approach us with the same, maybe slightly different facts, but should be able to avail of the exemption. So I think the regulator will be in a difficult spot.
Who is the competent authority then? Who can take that call?
So the way the competent authority here had been phrased, I think in the regulation related to the company law tribunal, which was originally supposed to be in place, or if there was a foreign regulator. I'm not so sure the competent authority which they have referred to is only the Ministry of Civil Aviation. I'm not too sure.
It would be a novel situation, right? If on the basis of a ministerial nod, a scheme is able to avail of an open offer exemption.
Right.
Fairly novel, right? I don't think I've heard of it before. I'm wondering if you have.
Yeah, it would be, because again, the Ministry of Civil Aviation is saying, look, I need to have the scheme approved for XYZ reasons relating to that industry.
Right.
The ministry isn't looking, and it does not looking at, okay, well, minority public shareholders, what's going on with them. Right. That is what the SEBI is there for.
Yeah.
So
SEBI could take a view that this is good for the minority shareholders, because otherwise you'd have this airline collapse. You have a new investor coming in who's willing to put in fresh capital and revive the airline and get it back on its feet. So just on those grounds, if SEBI was to offer some latitude, that in itself would also be an interesting precedent.
It would be, but I think you're right. The SEBI can overall say, look, that's fine, but I will look at each on a case-by-case basis. I have the power. As long as I'm exercising it reasonably, they may refer the matter to an internal body of experts and say, look, what do we think? This is a fit case, and we have the power, and why not use it? It is entirely possible, but that is again then the regulator taking a view that tomorrow if somebody else comes up, or a third acquisition or a fourth acquisition comes up, how am I going to say yes or no or differentiate? That's always, again, you've given yourself the power under the regulation. Use it if you can.
All right. So do you think in this case there will be an open offer or not?
I think if they get a specific exemption from SEBI, no. I think otherwise, I mean, let's see.
All right, Sandip, we'll leave it there. Thank you so much for joining us, and thanks for that legal insight. Sandip Bhagat there of S&R. We are talking you through why Ajay Singh's takeover of SpiceJet may not involve an open offer to ordinary shareholders.